Warning, censorship. Warning, censorship.
Do I have the right under the charter to exercise my right?
Officers! We live in Canada!
I have the right to speak what's on my heart!
Country!
Some people are looking for constitutional conversations. I'm not going to engage in those right now. I am focused on getting us through this pandemic.
Why is it possible that they are being held against their will?
Hello, I am Victoria Solomon, the legal coordinator for the Fight the Fines campaign. I'm joined today by Jenna Little. She's the head of our Ontario team that's fighting pandemic tickets. Jenna is amazing, and I'm so happy to be working with her. You're doing an amazing job. And I think we did a count today. We have nearly 1,300 clients in Ontario. Is that your calculation also?
Yeah, we have almost 1,300 matters in Ontario. There's some people who have multiples. But yeah, and we continue to grow, and we're so excited to be part of this project. And this is a real passion project for me. So thank you for having me on board.
Well, thank you for being here. And we've noticed that the same questions are being asked by our clients over and over again. Mm-hmm. And so I asked you to come here today to deal with some of those questions and to clarify them for the clients and for our viewers.
Great.
And the first question that comes up usually is, what kind of tickets are there? I believe there's 3 different types. Could you talk a bit about this?
So I'm glad that we're doing this because I want the public to be as informed as possible about this system. There are 3 different types of tickets. So they're called Part 1, Part 2, and Part 3. Part 1 is the regular ticket that you would get from an officer if you're pulled over for speeding, or usually if you're given one of the pandemic tickets, it's got a fine on it. You can respond to it within 15 days. Part 2 is a parking ticket. You're not going to see many of those in this context. Part 3 is a summons. Mm-hmm. So Part 3s are given to you when they think that your actions are particularly egregious, and they want to escalate fines. So the main difference between the Part 1 and Part 3, which are the most common tickets you'll see, are the fines. The Part 1 maxes out at $1,000. They also can't ask for jail time, whereas a Part 3, it is just maxes. I don't even know what it maxes out on. But it allows them to ask for much higher fines for businesses or individuals, and they can ask for incarceration as well. So that's really where that comes from.
And is the process for prosecuting this Part 1 and Part 3 tickets different?
It is quite different. So municipal prosecutors generally prosecute Part 1s, and provincial prosecutors or assistant crown attorneys usually prosecute Part 3s. I've noticed lately that in a variety of jurisdictions, they'll have maybe a municipal prosecutor do all of them or a provincial prosecutor do all of them because this is such a new legal landscape that they want to have someone who is extremely familiar with the laws doing everything in bulk. But the process is quite different. In terms of the Part 1, it's a ticket you have to respond to, so you have 15 days. And then they usually will send you either a notice of trial, if that's what you've requested, or a notice of early resolution, if that's what you've requested. And it's a pretty simple process. It's intended to be simple, and it's intended to be accessible by the public without having to get representation. So it creates access to justice. In terms of Part 3, it follows the same pathway and the same procedure as a criminal charge. It's called quasi-criminal for that reason.
And Part 3 is the summons, just to clarify it for the viewers.
Yeah, so that's right. So when you're given a summons, you're given an invitation to court. So it's a court date on a piece of paper, but that's just your first appearance date. You go in and you usually go on record, establish why you're there, what you want to do. You don't have to plead guilty or not guilty on that day, and then you'll just get a new day. It's very common for these types of offenses to go to court multiple times, 5 or 6. I've seen them go in the 20s. It depends on how complicated things get. A lot of these states are just administrative in nature and checking in with the justice of the peace to let them know what the status is. Eventually you can set a trial date, and you can either show up to your trial or not. If you don't show up for your trial, they'll have a trial without you. But with a Part 1, if you don't show up for your trial, You're just convicted. They don't have a hearing of any sort. Then you get a bill in the mail that you've got to pay.
Right, and this is why it's important to contest these tickets.
Absolutely. It's important to contest all types of tickets because you still have the presumption of innocence, regardless of what you're being charged for. If you've received a summons, you definitely need to attend court. They have the right to issue a bench warrant, which you don't want to have happen. They can also issue a warrant for your arrest, which obviously you don't want to have happen. And you should want to be able to defend yourself and exercise your due process rights.
Yeah, definitely.
So,
and then this third type of ticket that, you know, you
that's the
mentioned,
part.
what is that?
Well, there's another type of ticket which would sort of fall into part 2, and that's an administrative monetary penalty. Administrative monetary penalties don't really fall into part 2 because they don't have a provincial system. It's a municipal system that cities manage. The court is not involved. It's simply you speaking with a municipal worker in a cubicle. And if you don't like what they have to say, then they will transfer it to their friend in the next cubicle, and you can talk to them. But there is no court process, and so it's not regulated the same way. So.
And we've seen those tickets given to our own staff, to Efron Monsanto and to David Menzies in Hamilton. Have you seen other jurisdictions giving out those municipal tickets?
Yes, I have seen them. I've seen them in Toronto, in Mississauga, but for the most part in Hamilton.
Right.
Hamilton really likes to give out the administrative monetary penalties. It's a good revenue generator for them. I mean, I've gone through the screening process with several, and the screeners are very reasonable. But the system is it's unfortunately just kind of a dead end. There's nowhere you can really go. The good thing is that it is just a fee. It's just a fine, sorry. So and you can get that reduced. So it doesn't go on any kind of driving record or really impede your future in any way. So you can fight them and ask for a lower fine, and they generally will give it to you if you've got good reason.
Okay, no, that's great. And then another question that I've seen come up all the time, we're asked if someone's name is misspelled on a ticket or if their address is misspelled, clients think that these tickets will be thrown out. Is this the case?
No. So the majority of errors on a ticket are not considered fatal. There's a handful of them that are, and your legal professional, if you hire someone, will be able to navigate that for you. There is a specific way to navigate it. Even if you do receive a ticket that does have a fatal error, it's not an automatic thrown out thing. You still have to respond. You still have to go to court. You have to exercise that option. But unfortunately, the majority of errors that are on tickets are amendable, meaning as the prosecutor can amend it in court, or the officer can amend it prior to filing their copy of the ticket. So they're very strict about that stuff. They've really cut down the amount of things that are considered fatal flaws in the last couple of years. And it's unfortunate, but the spirit of the provincial offences system is to keep things speedy and to ensure that there is equitable access to justice for everybody. And part of being speedy is cutting down things like that.
And what kind of errors would be fatal in your experience?
So no set fine. No set fine is a big one. Not having the date would probably be one as well.
That's on the summons.
No, so this is only for part ones, actually.
Okay.
Yeah, and having the wrong section number as well. Again, if the officer amends it prior to filing, you're kind of dead in the water. It won't be fatal. But there are other ways that we can argue around that as well. When it comes to a summons, unfortunately, any error on a summons is meaningless. These things don't apply to summons. A summons is simply an invitation to court. It doesn't have to be perfect. The summonses are based off of what's called an information. And the information is what is before the court. And on that information, that's where the information needs to be correct. So if there's some sort of an error, a fatal error on the information, that could be quashed. But again, it's something that your legal professional would have to look into, because when you're fighting something on your own, you're not given a copy of the information. You have to ask for it. You have to know what to look for. And these things can get complicated after 15 different appearances. So.
And I think I remember I recall you noticed a number of people being charged under wrong legislation, and you were able to have those tickets withdrawn due to this error.
Yeah, that was a different kind of thing. That wasn't a quashable issue. It was just the wrong charge. So police were laying tickets that were not appropriate. It's akin to being charged with running a red light when really it was a stop sign. You know, it's the wrong charge.
Right.
And if that situation fits, then yeah, we're definitely going to argue that.
That's a fatal error.
It wouldn't be a fatal error. It's technically a triable error.
Right.
A fatal error is something that is on the certificate of the offense. That it means that the face of the certificate of offense isn't complete or regular on its face.
Right.
Yeah.
Okay. Well, our clients are lucky to have you to look out for errors like that.
I am happy to look out for them I love finding them. Great.
And another question that or statement that I hear often is that these tickets are not real, they're not constitutional, they will never hold up in court, they will be thrown out. How would you respond to this?
I see that a lot, and I think that's a really dangerous narrative, because then we have people who don't respond to their tickets, or they don't go to their summons date, and it becomes a nightmare for them, and then they get convicted or worse, and it ends up coming to us, and we have to explain to them, well, no, like, this is real. You do have to go to court. The constitutionality of it is something that can be challenged in court. It's a triable thing that needs to be brought in front of a justice of the peace. But these are absolutely real. There are multiple levels of laws that people can be charged with breaching, such as bylaws, or even like, so city bylaws, municipal bylaws. There's the provincial statutes as well. And there's criminal charges people can face as well.
And federal statutes.
Federal statutes as well. I mean, there's a lot of them, and they're real. And this hasn't gone to higher level courts yet to determine the constitutionality, because the court's been closed.
Yeah, and this is the reason why we haven't had trials yet.
That's right. Yeah, and they're slowly being set, which is great. And I'm really excited to see where they go and how these things go, because we are going to be filing a ton of charter motions all over the province. And it'll be very exciting to see how they work out.
Another question that comes up, we see people get 2 tickets arising out of the same occasion, and they're charged under different legislation. So they may be charged under the Emergency Management Civil Protection Act and under the Reopening Ontario Act. Why are people being charged, under these 2 different statutes and receive 2 different tickets, and how would that proceed?
I think that most people are getting charged with both of those because the officers don't know what stage they're in, or they've been told to just give both and hope one sticks. There is a difference between the 2 statutes. There are legal arguments that can be made depending on time and date and stage and what exactly is happening at that time. But both types of charges actually carry the same penalties, and one of them actually refers to the other. So it becomes quite redundant. So there's alternative legal arguments that we can make there as well, regarding double jeopardy or pineapple, depending on how the process works out.
Statutes and the regulations that we're dealing with are very complicated. And I believe you and I have looked into one of the regulations once, and we've noticed it's been amended 5 times in 1 month.
Yeah.
So, how can the defendants understand what exactly they're being charged under when these laws are changing all the time?
That's a really good question. It is ridiculously complicated for absolutely no reason. And there are regulations that have multi-day corrections, or 1 correction a day for 7 days in a row, and then they go 2 weeks with a correction. And every time there's a correction, that means that something within that regulation has changed. It usually will be highlighted when you look it up on, say, e-laws. But for a regular person, it's difficult to navigate this because there's so many different factors. But the most important thing to remember is you have to realize what stage you were in at the time. Were you in a red or gray stage, or step 1, step 2, step 3, whatever existed at that time. And then you have to find the regulation that existed on that date. And that's how you can pinpoint what the law was at that time. And it's really unfortunate that this system is designed the way it is, because when you get a ticket, it's just this generic wording that says that you just failed to comply with an order. It doesn't say fail to comply with an order and this is the regulation where that defines what you've failed to comply with, or this is how. It's very generic, and so people get confused and they don't know how to defend that something like that on their own. So I always suggest people, first of all, if you get something, get legal advice. If you can contact us, you can contact anybody, but if you're not sure about what's happening, get legal advice, and a paralegal can probably assist you with that.
Yeah, and this is why it's important, to have a legal professional, I think, look at these tickets and advise, because I think that a regular person would be very confused by these charges.
Yeah,
and it's difficult to defend on your own.
It definitely is, and I think that also leads into this narrative of the tickets not being real, because when you start to look into what these tickets are, it's just this random section in a statute that says you just breached an order. It doesn't say what order, and people's minds go to, oh, so it's just an order. It doesn't say what. But that's the interlocking relationship between acts and regulations, and you have to understand how they work together to defend something like that.
And what kind of regulation was in place, when at the time that you were charged, because they get amended all the time, is important to know.
Yeah,
and difficult
I think,
to pinpoint.
Absolutely, and I think it was confusing enough for the public when we were going from red to yellow to gray, and then lockdown, and then this and that, emergency orders, stay-at-home orders, emergency breaks. It was complicated enough with that, but when you start interjecting quasi-criminal or regulatory offenses into that, and you don't even know what existed on the day that you were charged, and there's piles of regulations for you to look into to figure it out, it becomes overwhelming.
Yes, and even now we've had many people ask whether the Emergency Act no longer exists, and it's not clear that it's the declaration under the Emergency Act that is not in place anymore, not the legislation itself. And I think that this type of stuff is very confusing for the public.
I've seen that a lot. I've actually had a lot of people send me that saying, look, the order is over. And I say, I agree.
Yeah.
The order has been spent. But that simply means we're not in a state of emergency right now.
Exactly.
It doesn't mean that at the time we weren't. And unfortunately, we don't have that retroactive protection for something like this because the law did exist at the time. Mind you, that is an argument that we will probably be attempting at some point.
We talk a lot about disclosure and how we need to request disclosure in order to be able to fight these fines. What is disclosure?
Disclosure is one of the most important parts of a case, and it's one of the most important entitlements that any defendant has for any charge. And what it consists of is the prosecutor or assistant attorney general or provincial crown's case against you. So it usually includes police officers' notes, narratives, there may be some media. And it can be as simple as just one page of handwritten notes, or it could be 1,500 pages of medical documents and 17 DVDs. It depends on how complicated your case is and what exactly the Crown is trying to prove. When you have disclosure for something that you've done, say you've been charged with something many times in the past and they really want to stick it to you, they're going to include a lot more there because they want to build a case against you. And it's your right to know exactly what that case is. And it's their obligation to give that to you as well. And it's very important for anybody, especially a self-rep, to not ever make a decision about their case without knowing what the evidence is against them. It's your right, and you can't possibly make an informed decision without knowing any of the information. It's just like you would make a decision about anything else that you decide on what to eat. You know, you're going to have information to base your decision off. And I see a lot of people, they get very excited or emotional or stressed out by court, and I completely understand that feeling. And it's too bad that kind of dynamic exists with court, but that doesn't mean that you should rush through your case. And it doesn't mean that you should make a hasty decision. Take your time, take advantage of what your rights are, and make a calculated and informed decision.
That's certainly good advice.
Yes, yes. And what we do is, for Fight the Fines, we request the disclosure for them. We review the disclosure, and then we circle back and we discuss with the clients what the disclosure is, what we've been offered. We also want to know what was their perspective versus what this disclosure says, because obviously it's only one side of the story. And it's good to share these types of things and have a good discussion about the case so you can figure out what the strategy is. And so I can explain to clients what the pros and cons are of each decision and what strategy I think we can go with, what could win.
We have a bunch of folks that have been charged with trespassing. They didn't wear a mask in a business, and they wonder if they were allowed to do that. And what are your thoughts about this trespassing charges for no mask in a business setting?
I find that that's the most common charge that is laid when it comes to masking in a business. There are multiple layers of law that people can be charged with for not wearing a mask, but trespassing is the most common, simply because a lot of these situations, people are going in, they're being asked to leave, and they're refusing. So then the police come, and you're getting trespassed because you've refused to leave.
And sometimes criminally charged, from what we've seen.
Yes, yes. Criminal charge is also a very likely thing, depending on how egregious your behavior is, and how, if you fail the attitude test, basically. Obstruction can be difficult to prove, so always get a lawyer for
Failure
that.
to obey.
Yes, always get a lawyer for that. But trespass is a little different. It's not criminal in nature. And we've seen them with people who have trespassed supposedly to go to the beach. They've disobeyed a sign on a fence somewhere, and then they've been given a ticket to trespass. So trespassing also enables the officers to arrest, whereas the Reopening Ontario Act and the Emergency Management and Civil Procedure Act don't allow for arrest powers. So it opens up that avenue as well. And when it comes to masking, there are a lot of exemptions. These exemptions are listed in various bylaws, or they're listed in the Reopening Ontario Act. But these exemptions aren't always honored by businesses. And things can get very complicated in terms of how a business interacts with a person and what kind of things they do to accommodate these people in their exemptions. They are obligated to accommodate. But when you go in and you refuse the accommodations or you refuse to leave, that's when they try to do the trespass. That's basically the only route they have.
We have businesses that have been given Section 22 orders. What are those?
Section 22 orders can be very serious. It basically is an order from a health officer who comes to your business and says, you have to close or you have to abide by ABC rules for X amount of time. They're not usually indefinite orders. I have seen indefinite orders, but usually they're time restricted, 15 days or something like that. And it really opens up the ability for a business to be charged exorbitant amounts of fines, up to $25,000 per day that they're open, if they don't comply with these orders. And it can get very, very serious and very escalated in a very quick amount of time. It's always good if you get a Section 22, definitely contact a paralegal or a lawyer. Contact us. We have a great set of lawyers who work on them.
Amanda and Nirmala Armstrong.
Yeah,
that
they're
have
amazing.
had some great success
dealing
with disorders.
Yeah, absolutely. Because they have an appeal avenue that exists, but it's so time sensitive because these things are temporary that it makes people think like, oh, there's no point in me doing this. But there is a point. This is your business. This is your livelihood. And we need to ensure that things are correct. And we need to do what we can to help you out.
And I believe that some of them are indefinite, are not limited on duration. I think I've seen a few that Nirmala and Amanda have been dealing with.
Yeah, we were talking about one. I don't remember who it was for, but we were talking about one that was indefinite, and it just blew my mind that this provincial statute, which is the Health Protection and Promotion Act, can enforce something like this indefinitely.
Right.
Basically just saying you can never reopen your business. But the thing that was crazy about that was that we went into a stage where they were allowed to be open.
Yes.
So you're telling these people that you can't be open indefinitely, even though the other laws all say that
the
you
province
can.
is reopening.
Yeah, which is, it's just egregious to me because this is a written order. This isn't a court order. This isn't a fine. But it does open the door to these multiple fines, and then further opens the door for them to try to yank licenses, like liquor licenses, tattoo licenses, stuff like that. So it gives a lot more power to people that we don't necessarily want to have that power, and we don't want to risk people's businesses. So just always get legal advice.
We have a number of people that have been charged at the airport, and people are wondering, are these charges real? Are they getting thrown out?
Yeah, so these charges are they're really crazy. They started at $3,000 plus surcharge. Now they're up to $5,000 plus surcharge. Originally, people were getting a $3,000 fine for not going to the hotel and a $1,500 fine for not doing the PCR test. Now they're just getting two $5,000 fines for both of those actions. These are real. The statutes do exist. It's complicated legally because it is a federal act.
That's the Quarantine Act.
Yeah, which is a federal act, not provincial, but it's being enforced provincially through the Provincial Offences Act. So the amount of fine on the ticket goes over what a normal Part 1, $1,000, would actually have. And at first it was very confusing. But then
I think they weren't being filed, as you noticed.
Yeah, they weren't being filed, and there was a lot of weird things. Yeah, yeah. And I think it's because nobody really knew what to do. Like the court computer system, does it input this high of amount of fine for a Part 1? We don't know. So I think there was a lot of confusion on everybody's end, including the officers who give out these tickets.
And the court staff, I'm sure.
Absolutely. I mean, that's the problem with these brand new ad hoc, offenses, right? Is it's just made up. But there's no real direction given to anybody, or nobody's really tested the waters to see how things are really going to work. But that's what we're going to take advantage of, and we're pretty excited about it.
And have you noticed whether this tickets are being filed now?
Yeah, for the most part they are.
Okay.
Yeah. I've noticed that a lot of these, so there's an online lookup that people can look up the status of their ticket. And while they're in quarantine, I mean, they only have 15 days to respond to a ticket, according to the ticket. So they look it up online and it says case not found, case not found. I'm finding that it's taking about 30 days for them to enter that in. Now, there is no rule or law that makes clerks enter in tickets within a certain period of time. And it causes a lot of distress to these people because they think, oh, God, I can't respond. I'm going to get convicted.
Yes, and they're in quarantine and they can't leave and they don't know how to respond to these fines.
Yeah, so
and they have 15 days.
Yes, exactly.
I see a lot of people panicking for
I
that
don't blame
reason.
them at all.
Yeah, no, not at all.
They would feel trapped, quite frankly.
Yeah.
I would feel trapped too.
Yeah,
and then you've got this looming financial threat of could potentially $12,000 in fines.
Or for a family, it can be just an exorbitant amount, over 20,000 in some cases.
It's absolutely insane.
Yeah,
it's insane and it's scary. And that's why for us, we don't take any chances with that. If it's case not found, we're filing it by email. We're just making sure that it's filed. We're not going to play games with people's finances and their lives. And we want to make sure that things are filed properly and that people don't get deemed.
And what would you say to people who are in quarantine and they have 15 days to respond to these fines? What would you suggest that they should do?
I would suggest that they contact us and we will handle it for them. We will file on their behalf by email to the court. Alternatively, if they're not ready to take that kind of plunge, I understand there's a lot that goes through your mind when you get a ticket. And you need to make an informed decision. That's okay. They could contact the court as well and just find out.
On their own and find out how to file these tickets while they're in quarantine.
Yeah.
Thank you very much for being here. This is great, very informative, and I think we've addressed some of the main and frequently asked questions that our viewers and our clients ask. And folks, you've heard and you've seen what we're doing. We have over 2,000 clients at the moment that we're assisting throughout Canada as part of our Fight the Fines campaign. And we can't do this without you. So if you like what you've heard and if you'd like to help us, please go to Fight the Fines and donate. You can donate through our democracy fund and get a tax-deductible receipt. Thank you, Jenna.
Oh, thanks for
Thank you
having
for
me.
being here.
It's my pleasure. Thank you for having me.